Thank you, Margaret. Thank you, Senator Lee, for joining us this morning, and thanks to all of you. Senator, your last book, Our Lost Constitution, was an argument that America has created a large governmental bureaucracy that has, in effect, taken over some of the lawmaking functions that were, in America's original design, reserved to Congress, and that shunted aside, in so doing, the constitutional protections for Americans, the constitutional limits on the government's power. As we speak, 1 in 4 people that is imprisoned around the world is imprisoned in the US. What is the constitutional failure, do you think? Does that reflect a constitutional failure? Does that reflect a misunderstanding of what the Constitution says the government is supposed to do? And if so, what is the misunderstanding? What was the failure there?
I think there is an argument to be made that that is one of many manifestations of our drift away from some of the fundamental protections in the Constitution, what I call the structural protections. The vertical protection we call federalism, that says most of the government should remain with the states and close to the people, where it can be turned around and where it can reflect local preferences. And then the horizontal protection we call separation of powers, that says we're going to have one branch, Congress, that makes the laws, another branch headed by the president that enforces the laws, a third branch headed by the Supreme Court that interprets the laws. When each function of government is allowed to perform only within its design sphere, you have government that's more accountable to the people. We have drifted from that. Now, it's maybe more of an attenuated connection, especially given that we've got a lot more people incarcerated under state authority than federal authority, but I think we've got a whole lot more people incarcerated under a federal authority than we should. Our federal prison population alone has increased about 900% since the early 1980s. This does not, in my opinion, reflect a 900% increase in the crime rate. It instead reflects a few trends in the law that I find disturbing: the over-criminalization of the law generally in this country, the over-federalization of criminal law, and the excessive use of often excessive minimum mandatory penalties within the federal system.
Now, you have been, and part of the reasons that you've joined us here this morning is that you've been an active voice on especially federal sentencing reform. You co-sponsored a bill by your colleague in the Senate, Senator Chuck Grassley, to address federal sentencing reform, to try to reduce some of the mandatory minimums that federal prosecutors can apply in sentencing. Now, this has been an area that, for the past few years, has seemed to be moving towards a rare instance of bipartisan consensus, and your bill reflects that. Within the Senate Judiciary Committee, your sentencing bill drew votes from both Democratic committee members and Republican committee members. However, there were a few holdouts, including your senior colleague from Utah, Senator Orrin Hatch. What is the disagreement? What was the disagreement within the committee? What were the problems? Who on earth at this moment is trying to keep mandatory minimums and having as much of a role in the system as they do, and why?
Without speaking for any one colleague, I usually try to avoid being anyone else's spokesman. But
so senatorial.
I can speak certainly in generalities about those within my party who sometimes express opposition. One of the things that I hear from some of my Republican colleagues is, I don't believe we have an over-incarceration problem. Some of them will go so far as to say, if anything, we've got an under-incarceration problem. I don't find that persuasive at all.
They say we should have 1 in 3 prisoners.
Yeah, perhaps, or maybe all of us should be in there in a sense. I don't know. Not all of them feel that way. Others will take a more nuanced approach and say, I could support this, but I want additional reforms in there. If you could throw in mens rea reform requiring a certain level of intent as a federal threshold matter on federal criminal offenses. And I understand that. My response to that one is, this doesn't deal with substantive offenses as much as it deals with the terms of sentencing and incarceration. That's more appropriate to address elsewhere. This has been an issue that has been building over time. When I first got to the Senate after being elected in 2010, I decided I wanted to work on this. It was a difficult thing to start initially. I started looking for allies on the Judiciary Committee, and I got together with Dick Durbin. Dick Durbin is a liberal Democrat from Illinois, and I've never been described as a liberal Democrat, or as a Democrat for that matter. But he and I see eye to eye on this issue and the need for reform. And so we put together something called the Smarter Sentencing Act, and that got a little support, and we decided we wanted to expand it. And we got together with Chairman Grassley and ironed out a series of compromises and put together the Sentencing Reform and Corrections Act. That passed out of the Judiciary Committee by a bipartisan supermajority vote of 16-5 just 2 weeks ago. And so we're making progress on this, and this could be a big bipartisan win if we would just bring it to the Senate floor.
Yes, and there is one key, there are a few key actors, in addition to some of the holdouts in the Senate Judiciary Committee. I mean, it was, passed with flying colors, passed the committee, and has many proponents in the broader Senate. But the White House has had an uncertain posture on this bill. And I'm curious if you could take us for a moment into a room that many of us don't get to be in for a while. You've spent some time with the White House, with Attorney General Jeff Sessions, who described this bill itself as a grave mistake. What's the flavor of that disagreement? Why? What has the cooperation with? What messages are you getting from the White House, and what cooperation do you expect looking forward on these issues?
So far, we've had enthusiasm expressed from the White House on Title II of the Sentencing Reform and Corrections Act and not Title I. Let me explain what that means. Title I deals with sentencing reform and makes some necessary adjustments to some of our minimum mandatory sentencing laws. Title II deals with some reform programs, so what we call back-end reform or reentry reform, helping to reform current federal inmates for their reintroduction into society so that they're ready to go, they've got some job skills, and they're less likely to recidivate after they get out. The White House has been more warm to Title II than to Title I. I still hold out hope because I still think this is good policy, and I think it's very difficult to argue against either Title I or Title II. I think they're best put forward together.
And part of that hope, as I understand it, as an outsider, rests somewhat on allyship within the White House. Jared Kushner, the White House senior advisor, has made sentencing reform among his bailiwicks. And I hear that as of last night, John Kelly has cleared aside some part of his foreign policy portfolio, and so he has more time, perhaps, to apply to criminal justice. How has it been? What has Mr. Kushner's engagement on the issue been from your perspective?
Jared has a lot of very refreshing ideas. He's also got a refreshing amount of intellectual curiosity. He likes to learn about issues like this, and he asks a lot of good questions. He has a lot of enthusiasm as a reformer. So I've appreciated the opportunity to work with him.
So I want to turn for a moment to the policy itself, to sentencing reform as one aspect of the broad problem, I think it's fair to say, of incarceration in the U.S. And its spread. Some would say that sentencing reform, and especially federal sentencing reform, is kind of nibbling around the edges of the scale of the problem. That because a relatively small percentage of those under correctional observation in the U.S. are federal prisoners. Now, this is where the matter of women is most directly affected, of course. Half of drug offenders that are imprisoned at the federal level are women. But it's still a small number of the imprisoned in the country overall. Most are state and local prisons. So what would you say to the argument that federal sentencing reform is kind of small ball?
It's a little bit like saying, I don't want to take the analogy too far, but if you look at a mile-long train, the engine car of the train is a very small portion of the train, but it's what's driving the train. In some respects, the federal system might be driving the states. Some of the states will look to federal law as a model in some instances. In other instances, you'll actually see state prosecutors or local prosecutors interacting with their federal counterparts and deciding which entity will take a prosecution in a particular instance, depending on which one is likely to produce a longer sentence. It might be one of the reasons why we've seen such an uptick in the federal prison population in recent decades, is because that sort of thing has been happening. They see a longer sentence likely at the end of a federal prosecution, the case is likely going to go federal. And so, yeah, even though this is a small segment of the overall incarcerated population in the United States, it is an important population. Most importantly, for my purposes as a federal lawmaker, it's the area that I'm supposed to focus on. So I'm going to try to reform this one, hoping and expecting, and so far, frankly, seeing that as we do this, we interest more legislative bodies in states to undertake similar reforms.
Is there a risk in the other direction, that if you do achieve a bipartisan success, legislation passes on sentencing reform, that it in essence makes a broader, more expansive set of policies on incarceration less possible down the line, that it limits the political will to come back to the subject and address some of the other areas that are where there might still be problems?
Perhaps if it backfired, that might be the result. I don't think it's going to, though. I mean, I think if we were to pass the Sentencing Reform and Corrections Act, I think we would see some very favorable outcomes. And that's why I'm very optimistic about the future for criminal justice reform. I think something like this passing is inevitable. I want to see it happen sooner rather than later. I would like to see us pass it this year. And I think we would see the fruits from that. I think they would be favorable and beneficial, and I think it would bring about more reform in this area that's needed.
I want to turn for a moment to the matter of the public and public opinion. We are having this conversation at a moment where there is broad agreement among Americans that the size of the American incarceration state has grown too large, and that we should explore alternatives to prison for some of society's ills that previously were construed as criminal. Now, this happens at a moment when crime in America, violent property crime, drug crime, is at a decade's low still. Every year we see a few headlines about potential spikes in some cities, but by and large, crime now in the U.S. is far lower than it was at the peak when several mandatory minimums and harsh sentencing guidelines were put in place. What if that picture changes? What if this goes the other way? Like in the 80s, we stand possibly on the precipice. We are amidst a huge drug epidemic again. There is an argument. Some are arguing that criminal penalties should be a solution to apply to that situation as well. What if law and order and tough on crime begins to get purchase in public opinion? Do you think that the successes so far in achieving bipartisan consensus in this are at risk?
With a representative government, it is hard for me to see it going in that direction. I don't see the will among the American people, the desire among the American people to say, yes, we've got this problem, and the answer is more cowbell, add more fuel to this very fire. You know, a friend of mine used to say that when you're holding a hammer, everything starts to look like a nail. And I think there is grave danger in that when it comes to the criminal justice system. If we see the government is wielding only one tool to combat the problem being broadly defined as crime generally, or even broadly defined as drug-related crimes, I think we're going to cause problems. I think we have caused problems to the extent we've done that. I visited a place recently in Salt Lake City called the Other Side Academy. It's modeled after a recovery home called Delancey Street that started out in San Francisco, branched out and opened another location in Los Angeles. They've had tremendous success with taking people who have served time, who have had problems with the law, often problems with substances, and they work together, they hold each other accountable, and they keep each other clean and off the streets and focused on gaining job skills and on becoming contributing members of a community once again. They've had tremendous success. They've been in operation now, they're in their 3rd year in Salt Lake City, and so far they have had a 100% success rate. Now, this is not a government operation, but in some instances, it's been used as an alternative to incarceration. There are some judges who have allowed people to go through this program rather than going and being incarcerated for a period of time. I think we need to look more at solutions like that if we really want to solve this problem. This is best understood as a human problem, and we have to examine not just the financial costs of lengthy mass incarceration, but also the human costs. The problems arise when somebody's son or daughter or mother or sister or aunt or uncle are put away behind bars, not just for years, but for decades at a time. There is a significant human cost attached to that, and I think we're reaping some of that, and that's why we need to look to other tools.
In a moment, I'm going to turn to the audience for a question. And first, I wanted to ask about a separate but related matter. I would be remiss, given our moment, and that we are still in the aftermath of the tragic shooting last week in Parkland, Florida, at Marjorie Stoneman Douglas School in Florida. There is one measure that has been endorsed by the NRA, the Fix NICS Act, that is intended essentially to strengthen some of the incentives around reporting gun purchases to the federal government. And it has a fair amount, given that it is endorsed by the NRA, it has a fair amount of support from across the aisle, as it were. But you don't support this measure. And tell me a little bit about your objection to it.
I'm trying to reform it. I'm trying to fix it. I'm trying to fix NICS. There is a fairly simple fix that I have drafted. There are some others available out there. Let me explain briefly what this does. The NICS system is a system that alerts people when someone is trying to buy a gun who shouldn't be buying a gun because they fit under one of the 9 categories identified in 18 U.S.C. 922G. People who have been convicted of a felony, of a misdemeanor crime of domestic violence, dishonorably discharged from the military, or one of the other 9 categories. Among those 9 categories is some language put in there, I believe, by mistake by Congress. Someone who has been adjudicated a mental defective. The problem with that is it's not a thing. No one really knows what that is. And the concern there is that you could have, among other people, veterans who are returning with PTSD. Somebody in the Veterans Affairs Administration has identified them as having PTSD and given them assistance managing their affairs in order to help them with that. They could be deemed, by a combination of action by the VA and a regulation put out by the ATF, to have been adjudicated a mental defective and therefore deprived of their rights. Now, that may seem like a simple problem to correct, but once you do that, and a culture develops among veterans where they're afraid to get help upon their return, you could end up with some real problems. You do not want returning veterans refusing to get treatment or help from the VA simply because they fear that they might be stripped of their right to carry that which they've been asked to carry in defense of their country. I'm trying to fix that. I think we can get to a fix on it, but it does need to be repaired.
Let me turn to a question from the audience. Oh, right over there, I think.
Hi, Senator. Thank you for being here today. I have a question related to...
Please just quickly identify yourself.
My name is Anna, and I work with the Public Defender Service here in D.C. And I have a question actually related to what you just mentioned with the mental disabilities. I know in the past year, Congress passed an act that allowed people that were severely mentally incapacitated, like to, you know, that have people that have other people, for example, managing their benefits. That used to be a prohibition that you couldn't go and get a gun, but Congress passed a law that allowed people like this to get a gun. I see your example about veterans, and I understand that, but when we're facing a culture of mass shootings in the United States, how can we both address the very real mental health issues that exist while also making sure that people like that are not capable of owning and purchasing a weapon?
Yeah, it's a fair question. And first of all, thank you for what you do. Public defenders perform such a valuable role in our society, and I appreciate what you do.
I'm sure she'll remember that in the appropriations process.
Yes, yes, exactly, exactly. I think it is important to make sure that people who should not have a gun don't get one, including people who have violent tendencies or propensities, people who are mentally insane, anyone who's been adjudicated, for instance, as unfit to stand trial, not reasoned by guilty of insanity, someone who has been committed to an insane asylum or something like that, or has been deemed by a court of competent jurisdiction to be a harm to themselves or a harm to others. And so that's what we're trying to tweak there, is we want to make sure that there is a definition behind that, rather than this broad term of adjudicated as a mental incompetent, to conflate that with someone who is returning home having served in the armed forces with PTSD and who needs help managing their affairs. That is not the same as somebody who has truly been adjudicated as someone who is a harm to themselves or a harm to others. We've got to make sure that there is due process in that. It's also helpful, I think, to rely on what a number of states have been using, and I think we need to examine our federal laws to figure out whether we should supplement federal law with something like what a number of states have adopted in the area of domestic violence restraining orders. When a cohabitant or a close family member sees something in another person that causes them to believe that they could be a threat to someone else, they ought to be able to report them to the authorities, and at least for a period of time until they can get it worked out, have that person put on the list of people who are unable to acquire or possess firearms.
Senator Lee, thank you for your answer. It's been
Thank you.
great start to our morning, and enjoy the rest of the festival. Thank you.